Okay, I'm going to go ahead and get started. Let me stop the share and pop myself into the main view. Hi, everybody. Thank you so much for joining me tonight. I'm really happy to have you here so that I can discuss some really interesting vehicles for estate planning and some interesting planning devices. I'm just going to give a quick introduction about me, and then I'll just dive right into the material. So my name is Melissa Keys. I am a California estate planning attorney. I started my career about 15 years ago, not in estate planning, actually. I was a corporate litigator for about a decade. And I worked for some very big law firms in New York and San Francisco and the Silicon Valley. And a few years ago, I decided I wanted to take the knowledge that I had gained from working in those very high wealth environments and bring it to Main Street, bring it to the middle class. So I started Jane Legal as a way to share the knowledge that I have and to bring the vehicles and the information that the very wealthy use to maintain their wealth to everyday folks just like you and me. So that's me. And I'm just going to go ahead and dive straight into the material. Let's start talking about real estate as an investment. As you all know, most real estate ends up being a person's largest asset. And in California, that is definitely the case. I am a California attorney, so I'm going to be speaking about California tonight, but a lot of what I have to share is generally applicable across all states. There are a few matters at the end of the presentation that are relevant only to California law, but most of what I have to say is pretty generally applicable in case you happen to come from another state. So yeah, California real estate is very valuable, as those of us who live here know. It is a solid long-term investment and grows drastically over time. So I'm showing you here a graph that I pulled from the California Legislative Analyst's Office that shows California housing prices over the last 80 years. And in comparison to other states in this union in the United States. And as you can see, not only does California real estate appreciate faster than housing prices in other states across the union, but it also appreciates more, and greater volume. So when you look at 1940, we were pretty close to the average for all American house prices. But as you see over the last 80 years, that has gone up dramatically, and the differential between California and the remainder of the states is quite substantial. So it's highly likely that if you own California real estate, that will be the largest asset in your portfolio, probably by quite a lot. And that being the case, it's really advantageous to have mechanisms in place that will not only protect that real estate and its value throughout your lifetime, but also the lifetime of your heirs. And that's really what we're here to talk about tonight, is how do you preserve that asset's value through the generational transfer to your heirs. All right. So moving on, I'd like to talk a little bit about the advantages of real estate over other forms of wealth and other forms in particular of generational wealth. Now, I took a couple of the more standard types of wealth generation mechanisms and did a little comparison here for you. First, let me talk about cash investments. So cash investments are things like your bank accounts, your savings accounts, your checking accounts, your money market accounts, even perhaps gold if you hold that too. The disadvantage of cash investments versus other forms of wealth building is that cash investments are easily liquidated. All right. So they are not, excuse me, they are not, there aren't too many barriers between you and your access to that cash. All you got to go do is go to an ATM and pull out some money. All you have to do is go to your computer and and transfer, right? So it's really, really, really easy to liquidate that investment. And that's what makes it really, really important to hold real estate versus a cash investment, because it's a lot harder to liquidate that, right? You got to hire a sales agent, you have to sell it, you have to pay your taxes, you have to pay the agent's fees. All of these are obstacles to liquidating that investment. In addition to that, you should note that about a third of individuals who inherit cash are in negative savings within about 2 years. So that's a pretty scary prospect, especially when you start talking about unexpected deaths. So say one of your children inherits when they're still a minor. Say one of your children inherits when they're a young adult. It's very, very easy for people who are not savvy with investments to end up depleting them very, very quickly. So again, it's all about the barriers, right? It's all about the barriers to liquidation. Now, retirement accounts are another really great way to go ahead and pass wealth to the next generation. However, there was a new law passed by Congress in either 2021 or 2022. I don't recall off the top of my head, wherein retirement accounts that pass generationally must be liquidated within 10 years. So, excuse me, not liquidated, I should say withdrawn from the retirement account within 10 years. So that means that you are having to pull the asset out of the investment vehicle. And if you're very savvy, or if your heirs are very savvy, then they're going to go ahead and put that into another investment vehicle. But chances are that they're not. And so one has to be very aware that, again, that becomes liquidated very quickly within 10 years. And the barriers just aren't there anymore. So it is very advantageous to be able to put your generational wealth into real estate where there are more barriers. So moving on, family businesses. Family businesses are another popular way to transmit wealth from one generation to the next. However, the problem with family businesses is they don't last. Family businesses, by and large, about 70% of them don't last that first generational transfer from the first to the second generation. So what you end up with is another liquidation event, another event where somebody, one of your heirs, is selling off the value that you spent all of this time building up, and it's simply not being transmitted to the next generation or even the generations after that. Only 12% of family businesses survive the transition from the second to the third generation. And so, yeah, that's definitely not as solid of a way to transmit wealth as a house. And in addition to that, it's also a little bit trickier because of the debt situation. So mortgages, by and large, transfer directly to the heirs. The banks want to keep collecting their money on the mortgage that was in the hands of one generation, and they will continue to collect it from the person who inherits. That's not necessarily the case with business loans. Business loans are a little bit more dependent upon who is running that particular business, right? So if the business owner passes away and passes that asset to another generation, that next generation might not have the reputation with the lender that the original owner did, and therefore those debts could be called in and the debts or canceled, as it were, and therefore the sort of life force behind the business isn't as available to the next generation. So again, real estate is just a really good way to transmit wealth across generations, in large part because the debt travels with it and because it's not easily liquidated. All right. Okay, so what are we protecting real estate from? Uh, there's four different things we're protecting real estate from. We're protecting it from liability. And let me just take a pause to talk about what that is in case you're not familiar. Liability is essentially a debt that you owe somebody for an injury that they incurred on either your property or because of you. So if you hit someone with your car, you incur a liability. If someone slips and falls in your house, you incur a liability. If you own a business and that business gets sued, that's a liability. All right. The second category of things that we need to protect real estate from is probate. Probate is, and I'll talk about this in a little bit more detail later, but probate is the process by which assets are transferred from a deceased person to a living person. This happens through the courts, through your state courts, and it can be quite a lengthy process and quite an expensive process. So I'll talk about that a bit more in later slides, but suffice it to say, definitely something you want to protect your real estate from. The third category of things that you want to protect your real estate from is taxes. And here I'm talking about taxes that occur upon a death. So estate taxes, generation skipping transfer taxes. And we're going to talk in depth later about the property taxes, which in California just got a major overhaul. And that is going to be a big feature of what your heirs are concerned about when transferring real estate from one generation to the next. The last thing is divorce. So there are vehicles that can protect your heirs' real estate inheritance from their potential future ex-spouses. And that can be a really big benefit because, at least in California, we are a community property state. And therefore, we have a situation in place where basically as soon as you get married, anything you accumulate from that point on becomes half of your spouse's. And there are ways, so if you accumulate real estate during your marriage, that is going to be half owned by you and half by your spouse. And so there are ways to protect your heirs from having to divvy up the real estate that you give them in a potential future divorce. All right. So let's move on. This is the image that I sent out to you in advance of this presentation to give you a little taste of what it is that we're talking about tonight. And I'm going to go through each of these tiers in order. Each of these is a little bit more of a building block on the next. So I'd like you to think of it as the top level being your basics. All right. You want to start here. Going straight to the bottom level is not going to give you the protection that building these layers up will. The bottom layer will not replace the top layer. So we're going to go through each of these layers from the top to the bottom in detail and in succession as building blocks on each other. All right. So let's go ahead and let's talk before we get into the first level. Let's talk about liability and what it is, where it comes from and what we need to be worried about. So as I mentioned before, liability is essentially a debt you owe to somebody for injuring them or injuring their property. These are the subjects of lawsuits, right? So as I put in here in 2021, there were 63 million lawsuits filed in the United States, and that is a very large number. And I would venture to say that probably a tenth of those were filed in California. California is a very, very litigious state. And so what you want to do is to protect yourself from that, right? There are two types of liability. One is inside liability. So that's liability that is attached to a particular piece or a particular asset. Things that are related to, in the example of real estate, your real estate. So that could be a slip and fall on your property. That could be overdue tax liability. That could be a tenant's claim on a rental property. There are a number of different things that you could become responsible for as a real estate owner. And those are the things that we consider inside liability. They're inside the bucket of your real estate. There are things that are outside of your real estate that you could also be liable for. So say, for example, you get into a car accident and you're the one who is at fault. You may be sued by the person who you hit, and that is an outside liability. It's not directly related to your real estate, but unfortunately, if you don't protect yourself properly, you could expose your real estate, what's inside that bucket, you could expose your real estate to that liability. So let me give you an example. Say that you own a business and one of your clients sues you for, say, breach of contract. And you haven't set up the proper protections to segment your business from your home ownership. And so what happens in that case is that if the person sues you for more than your car insurance will pay out, you could be your assets within the bucket, your home, your personal bank accounts, anything like that could be exposed to that lawsuit. You may have to pay out from those assets to this other vehicle owner for the injuries that they incurred. So the first thing, the basic level of protection that you're going to want to put in place is liability insurance. All right. I'm not an insurance broker, so I don't know from who's good at this and who isn't and what exactly policies entail. But what I do know is it levels the playing field. All right. As a former corporate litigator, what it is that I was doing was I was in the courtroom all the time. And I can tell you with relative certainty that 99 times out of 100, the person or the party with the most money wins. It's an unfortunate feature of our court system. And it's not something that yeah, well, it's an unfortunate feature of our court system. And a way to level the playing field is to put an insurance carrier between you and any liability. They take over the case, they take over the settlement, and they pay out from your policy any damages that you might be found liable for. Now, your homeowner's insurance may have some liability protection against personal injury on your property, but chances are it's not very much. So a liability policy, also called a personal liability policy or an umbrella policy, is going to put an umbrella over all of your assets. So basically you're insuring everything within your net worth as against a claim that's either coming from inside any particular asset or a claim that's coming from outside any particular asset. And it's just shielding you in general from the outside world and frankly, our own court system. So that's the first layer I would say is absolutely necessary for any California homeowner to preserve the value of your real estate during your lifetime. All right. So let's jump into that number 2 thing that we need to protect ourselves from, and that's probate. What is probate? Probate is a court process by which assets are transferred from a deceased person to a living person. Probate is expensive. Probate is expensive along 3 different vectors. One is time. In California, you're looking at about 2 years from beginning to end of getting through that probate process. And this is time in which your heirs are bereaved, they are mourning, and yet they still have to make court appearances, they still have to make court filings, and they still have to pay out money that they might not have available. All right. The next thing that is very costly in probate is privacy. You will lose a lot of your privacy, and your heirs will lose a lot of their privacy because every court process in the United States, with few exceptions, is open to the public. And therefore, all of that stuff that you had preferred be kept within the confines of a will, within the confines of a private document, is going to be publicly available. And there are, unfortunately, people who just sit in courtrooms and wait for that 18-year-old who's inheriting $2 million so that they can take advantage of them. So it's a tricky thing to lose your privacy in this context, and definitely not something that's going to benefit your heirs. The last thing about probate that makes it costly is that it costs a lot of money. So probate is going to cost you about 5% of your total net worth. And so just to give you a little bit more of an illustration, if you take the average California home value, which is almost $750,000, the cost of administrative fees, court fees, attorney's fees, etc., is going to average out to almost $40,000. And that needs to be ponied up by your heirs before they ever even get access to your assets. And so it can cause a lot of strife in a time when people are mourning your loss to try to come up with those assets. Another little interesting bit about probate that you need to know is that your probate costs are calculated off of the fair market value of your assets. So say half of that average home value is still held in debt. You have a mortgage for about $375,000. You own about $375,000 in equity. The probate costs are calculated on the total, not just what you own. Probate does not take into account debt. So those costs are actually going to be on your average California house quite high, even if your equity is low. Now, in comparison, I'm showing you on here, the cost of a trust is about a ninth of what you're going to end up spending in probate. The average cost of a trust in California is about $4,000 to $4,500, and a trust will entirely avoid probate. Now, let me repeat that. A trust will entirely avoid probate. So your heirs do not have to go to court. They do not have to spend 2 years there. They lose none of their privacy. And all of those costs are kept in your heir's pocket. All right. So that's a huge advantage. And that's why I strongly recommend a living trust. I'll show you here as the next layer of protection and really part of the basics. This is what I would say any California homeowner really should have in place. So let's go back and talk a little bit about what a trust actually is. Now, I'm using the qualifier living trust. A living trust is one that you create for yourself, right? You are essentially creating this imaginary entity that is separate from you, that holds all of your assets, but doesn't die. So because it doesn't die like a human being, it doesn't have to go through probate. So what happens is that anything that's held in this trust simply the benefit of it rather simply transfers to your heirs upon your death in a very seamless process that takes place privately in a lawyer's office. And no one else needs to know who inherited, how much they inherited, any of that. Like I said, it costs about a ninth of what the average California homeowner would pay in probate. And it is the only way to avoid probate. It's essentially an agreement between you and you and you. You as the grantor, the person giving the assets into the trust, you as the trustee, the person administering the trust, and you as the beneficiary, the person who receives the benefit of the trust. So it's an ideal way to transfer assets from one generation to the next. And I think every California homeowner should have one of these. So again, rolling back to what I said before, I think the basics are for any California homeowner, liability insurance to protect it during your lifetime, and a living trust to make sure that that asset, passes, intact to your heirs without having to be liquidated or being exposed to public scrutiny during the course of probate. All right. So let's talk about the next step. The next step is really for people who are looking at real estate as an investment. So this is more than just, and not to say that you couldn't use this for your primary residence, but adding these extra layers of protection are really probably more beneficial to people who own multiple properties, multiple rental properties, multiple commercial properties, multiple homes. And so that's why I call it the next step. It's the next layer of protection for people who are diving a little bit deeper into real estate as a method for generational wealth transfer. Let's talk first about what a limited liability corporation is, and then I'll tell you the instances in which multiple LLCs are valuable. So first, I should say LLCs are really, really valuable for protecting your assets against liability. All right. They can be valuable from protecting you against taxes in a generational wealth transfer situation. But let's talk first about the liability aspect. Now, why they work is because they basically split off your assets into different buckets. Bear with me for a moment. In dividing your assets into different buckets, you are essentially shielding one part of your holdings from another part of your holdings. And so any liability that comes at either side is shielded to just that side. So let's say you have an LLC in which you hold your primary residence, and so that is your corporate assets. That is the bucket over here on the left. And this is the bucket that is liable for anything that happens in or around the home. All right. And then you hold another bucket entirely, and that's your personal assets. That's your personal bank account. That's your stocks and bonds. That's your IRAs. That's your clothes and your dog, maybe. The idea of an LLC, a limited liability corporation, is that it creates this fictional corporate veil between your corporate assets, what you hold in the LLC, and your personal assets, what you hold in your own name. And as long as you maintain, and we're going to talk about that in a little bit, as long as you maintain that barrier between the two, you will be able to shield one half from the liability of the other half. So this is a really, really, really useful way to limit your liability in any one situation and to preserve one half or one part of your assets from the other. Now, what they require. LLCs require some maintenance, and that's why I say that they are more valuable for people who are looking at real estate as an investment vehicle, who own multiple properties, because it's a little bit more paperwork. Okay, so you have to pay the taxes on it. You have to pay your state, in our case, California, $800 per year to maintain the registration of that corporation. You also need to get a separate taxpayer ID for that corporation. And in the case where more than one person is a member of that corporation, you're also going to need to file a separate tax return. You can keep it as just a single member LLC, so only you have control over that corporation. In which case, you just you file any income under your own personal income tax return. But again, if you split it, you're going to need, it gets a little bit more complicated. The absolute most important thing about an LLC is that you maintain the corporate formalities. These are things like holding annual meetings, like having an operating agreement, having records, accurate records kept. And above all of that is having separate bank accounts and lines of credit. You do not want to commingle assets, meaning you don't want to pay for the bills or the liabilities of the bucket that holds your corporate assets with your personal assets and vice versa. That's called commingling assets. So say you have property taxes due on the home, which is owned by an LLC. You want to pay that out of the LLC's bank accounts, because when you start paying from it for that kind of stuff from your personal asset bucket, you're crossing this corporate veil. And when you do that, what happens is that veil gets weaker. And if somebody comes after your personal assets, because that veil is weaker, they might be able to get at your corporate assets and vice versa. So you really do need to maintain separate bank accounts, separate lines of credit. You need to maintain all the corporate formalities and do not commingle assets. So really quickly, in the case of multiple LLCs, as I mentioned before, those can be very beneficial when you own a lot of different properties and you want to keep each of them segmented from the liabilities of the other. So say I have two rental properties, a primary residence, and then an IRA in my personal name. I would want to separate the liability of those that could incur at either of those two rental properties from each other. I would want to segment that from the liabilities that I could incur in my personal residence. And I certainly want to separate that from what could be incurred from my personal side. So having multiple LLCs as a vehicle to simply, again, segment off your wealth in different areas so that anything that happens to one area doesn't affect the others. Okay, so then let's talk about that final tier of protection, the full package, I call it. The full package is really this is some really heavy duty planning here. And the reason that I say that is that this is a layer of trust, a layer of protection rather, that can be costly. So it's ideal for those people with larger estates to pass on. It has benefits that the other layers of protection don't have. An irrevocable trust, so here in the green, an irrevocable trust is what is going to protect you from it's not me, not you, and I'll explain why not you, your heirs from potential future ex-spouses, and protect your heirs from estate taxes too. So irrevocable trusts, just really briefly, are different from living trusts in that they are concretized. They are more or less set in stone. And so, whereas with a living trust, which is also called a revocable trust, the person who creates it, you, can disassemble it. can take it apart, can remove assets from it. It's a very thin veil that exists between you as a person and you as the trustee of your living trust. With an irrevocable trust, what makes it valuable is that that's not the case. So it's something that is more locked into stone and therefore provides extra protection. So let's talk about those a little bit more. There are a couple different kinds of irrevocable trusts that we're going to talk about today and that are important to this discussion. They are an asset protection trust, which is a trust that operates in large part like a corporation, in large part like an LLC, and that it puts assets into a different bucket. And this barrier between the two is not called a corporate veil anymore. There's really no term for it, but there is functionally a division between the assets that are in the trust and your personal assets. Now, irrevocable trusts are by and large created at a person's death. So a living trust becomes an irrevocable trust at death, just by operation of the trust itself. The reason why that's the case is because, first of all, setting up an irrevocable trust under your own name is not permitted in most states, including California. And in addition to which, there are a lot of tax consequences. Unlike with LLCs, there's a lot of tax consequences for setting up an irrevocable trust and then putting your assets into it. So an asset protection trust you can create it in your lifetime, and it's a very valuable mechanism for dealing with estate taxes. But by and large, asset protection trusts are for your heirs. They are the bucket in which your heirs can keep these assets that they inherited from you separate from all of their personal liabilities, separate from all potential future ex-spouses. And so it can be very valuable, and in fact, more concrete than actually even an LLC. Income can flow from the asset protection trust to the individual that is the beneficiary without sort of breaching that line. And that can be quite a valuable passive source of income for your heirs. Another type of irrevocable trust is a dynasty trust, and it's the same idea as an asset protection trust. It's simply designed to last longer. So it can last multiple generations. It helps to avoid estate taxes at each of those generational transfers. And that can be really valuable when your estate is very large and you foresee that it is able to provide income for generations and generations to come. So, if you have the luxury of having a very large estate, these trusts can provide for generations down the line without having to be slashed by estate taxes at each generation. So it's definitely something that is valuable for just what we're about to talk about, which is taxes. Before I get into that, I want to talk to you a little bit about the differences, the similarities and differences with a corporate form like an LLC. So in the black, you'll see the similarities between an LLC and an irrevocable trust. And they both provide protection against outside liability. So again, there's those two buckets in both scenarios, right? With the veil in between. They both require a little bit extra footwork, a little bit extra paperwork, separate taxpayer IDs. And in the case of an irrevocable trust, you definitely will have to file an extra tax return. So those are the similarities. The differences are big, actually, and those are in blue. You will lose control of those assets in order for it to be an asset protection trust. You actually need to give off control to somebody else, because if you still have control as a trustee of that asset, then you could liquidate it, right? You could, if you are sued personally, you would be able to liquidate that asset and then pay it out to the person you're liable to personally. So the way that they work, actually, the primary mechanism by which they work is they actually separate out those roles of trustee and beneficiary, and they give control over the trust to somebody else. And now this can be a big reason why a lot of people don't want to create them, and a big reason why people create them at death, right? Because there's no control. They can keep control during their lifetime with a living trust and then hand over control once they're no longer around to need it. There are tax consequences for transfer, unlike with an LLC. So you have to worry about, say, if you create an irrevocable, or sorry, an irrevocable trust is created for you within your lifetime, and you want to move an asset into that trust to shield it from your liability coming at you personally, you're giving it away. So you have to pay a gift tax on that. And that can be pretty big. I think gift taxes are in the 40% range. So that's a big chunk. And again, like I mentioned before, unlike an LLC, you cannot create an irrevocable trust for yourself in California. You have to have one created for you. So again, another good reason why they're generally created at death. A couple other things about asset protection or irrevocable trusts are in green. These are great protection against potential future ex-spouses. I can tell you from experience that they are almost rock solid as against a divorce. And so can really benefit your heirs from the potential of having their assets divided 50-50 in a divorce. It also, as I mentioned under discussion about dynasty trusts, they are a great way to avoid taxes entirely at the transfer at death. So not avoid taxes entirely, minimize estate taxes at the generational transfer on the occurrence of a death. So again, a very valuable vehicle for estate planning. Now, let's dive straight into the taxes discussion here. Estate taxes are there's three different buckets of taxes that you're going to need to worry about at a generational transfer. One is the combined bucket of estate and gift taxes. So what happens at a death is the IRS looks at all of your stuff, and that's your estate. And they also calculate in any gifts that you gave during your lifetime, and they put that all into one number. And that number is taxed. Now, whatever your political leanings, you should know that right now we're in a very advantageous situation because of former President Trump. So, and also former President Obama, they created a very large estate and gift tax exemption. I think in Obama's era, it was at $5 or $6 million. And in Trump's era, it went up by twice. And so right now in 2023, we're looking at an exemption amount of almost $13 million. Now, let me take a step back and explain what an exemption is. If once the IRS calculates that total of your estate and all the gifts you've given in your lifetime, if that comes to less than $13 million, no estate taxes. So that's the vast majority of us, right? Most of us will not have to worry about estate taxes. Now, that is going to change in 2026. That's due to ramp back down by half to about $7 million is the current estimate of what that's going to go back down to. That's going to depend on who holds Congress in 2025. So something to keep an eye out for, but definitely something we estate planners are keeping an eye on, because yeah, that's a significant drop down in the exemption amount. So if you are lucky enough not to have to worry about that, great. If you're lucky enough to have to worry about that, then you're going to want to keep listening to the rest of what I have to say. And you're definitely going to want to think about those irrevocable trusts, particularly at your death. There's another bucket for taxes that gets assessed at death, and that's generation skipping transfer tax. So these are taxes that are assessed against the assets that you pass down to two or more generations below you. So not your kids, but your kids' kids, your grandkids, and then below that. So that's assessed on in a totally different bucket. There is a similar exemption, however, for that. So there is right now in 2023, you can pass almost $13 million to your grandkids without having to pay that extra generation skipping transfer tax on it. And again, in 2026, it mirrors the estate and gift tax. So that is also going to go drop down by half in 2026. Okay. So let's go to this third bucket. This is really where, for most of us, where the rubber meets the road. Property taxes. So property taxes are not due at a death. However, a couple years ago, the California population, through ballot measure 19, Proposition 19, passed into law a new provision that requires a reassessment of the value of your property upon a generational transfer. So this came as a really big shock to people, apparently, and because it changed basically everything about passing real estate. It used to be that you could grow real estate for a long time in your lifetime, and then pass that with the value of the property as you purchased it for property tax purposes to your children. So they would say you bought a house for $30,000 in 1972. Well, your children used to be able to inherit that with a property tax basis of $30,000. That is no longer the case. So starting in 2021, now you can only, you are automatically, a generational transfer will automatically trigger a reassessment, except in very few cases. Things like when the heir is a disabled person or a veteran. So there are limited cases where their reassessment will not be triggered, but again, for most of us, that's not the case. So property tax reassessment is going to be a big, big, big problem for heirs in a generational transfer scenario. So how do you deal with that? And that's the next slide here. You can avoid property tax reassessment with a few different ways. One is you sell the property within 1 year. Now that runs into all the problems we talked about liquidating an asset, right? It removes the barriers between cashing that out and then using that for expenses. However, it can be very useful in situations where you say have one house and 5 kids, right? And you need to distribute that between multiple heirs in order to provide for your heirs. This works for any type of property. It works for rental properties, commercial properties, residential properties, and your primary residence. If you sell it within 1 year, no property tax reassessment. That's the problem with the new buyer. Another way to avoid property tax reassessment is to move, and this is only going to work for primary residences. So this is only for the residence that you live in at your death. And it does not apply to rental properties, does not apply to commercial properties, does not apply to second homes. Okay, so if an heir, even if you have multiple heirs, if an heir moves into that property within 1 year and makes it their primary residence, you can avoid property tax reassessment. So that heir will be able to maintain that $30,000 purchase price as a property tax basis when they inherit it 40 years later. So that's a great way to transfer a large amount of wealth. But again, it only works for a primary residence, and you can lose it. So as soon as that heir moves out, or let's put it this way, different heirs can move in and keep that as their primary residence and avoid the reassessment. But as soon as no one is using that as their primary residence, then a reassessment is triggered. So again, another great thing to have, but you have to be diligent about somebody keeping that as their primary residence. And then last but not least is the use of LLCs. So this is a really interesting workaround that was actually devised before Proposition 19 and is becoming increasingly more regularly used after Prop 19 in order to avoid that reassessment. So this can work for any type of property, commercial, residential, and rental. Ideally, the way that you want to do this is you want to purchase the property in the name of an LLC you already have set up. This allows you to use a minimal amount of transfers between you as an individual, you as the LLC and your heirs. You do this in a process of moving less than 50% at any one time, and you can do that if you pretty seamlessly, actually, and pretty quickly if you purchase the property in the name of an LLC. If you don't purchase the property in the name of an LLC, it's a little bit trickier and it's going to take a lot longer to do. So you can set up an LLC, put your primary residence in it, and then use a series of transactions over the course of, I would say, ideally 5+ years to transfer the LLC's membership interest from you to your kids. And this requires the use of multiple LLCs. This requires time, I would say ideally 5+ years, in order to avoid what the IRS calls a step transaction, which is a number of steps that are used to cumulatively create one transaction. When you space them out sufficiently, you avoid the likelihood that that's going to be the case. Now, this is still an uncertain strategy. Prop 19 is still pretty new. And while many attorneys are using this strategy, it's going to be highly dependent upon the county. And it's also going to be highly dependent upon what comes down from the courts in the next few years and from the various counties. So definitely something that is worth looking into, is definitely worth trying. As I said, a lot of estate planning attorneys are trying that right now, but it's still somewhat of an uncertain strategy. All righty. So that is actually the conclusion of my presentation. And I want to say thank you so much for attending this presentation. I appreciate your time. I appreciate your attention. I appreciate that you are educating yourself on these matters so that you can increase the likelihood that what you are trying so hard to build up in your lifetime will be passed to your heirs in the most holistic manner. So as an added bonus for sitting and listening to all of this, I'd like to offer you a free gift. If you contact me within the next 24 hours, either by email, I'm going to give you my email in just a minute here, or you book a complimentary consultation with me via my Calendly calendar, I will grant you a free life and legacy planning session. So this is normally a $750 value. This session is a 2-hour working meeting in which We sit down, we talk about your family dynamics, we talk about your assets, we talk about what your wishes are, and I would explain to you what would happen in the absence of an estate plan. Now, if you don't like that consequence of not having an estate plan, we actually can design the plan in that meeting and get you protected and get the processes in place to protect your heirs. Now, again, that's it's normally a $750 meeting, but because you graciously gave me your time this evening, I'm going to grant you that free of charge. But you have to contact me within 24 hours. That's the one thing that I need from you. I need you to contact me within 24 hours to claim this. In addition, if you do move forward with an estate plan with Jane Legal, I will give you an additional $250 off any estate plan that you engage me to create for you within the next 60 days. So again, that's a total value of $1,000 of free legal services if you contact me by email or by booking a complimentary consultation within the next 24 hours. So let me give you the information about how to do that. You'll see here my email address is on the lower right-hand corner of the screen, and I have a couple QR codes here for you. The one on the left is the one that you're going to need to use and book a complimentary consultation with me within the next 24 hours in order to claim that free gift. And if you know already that you want to move forward with this, then please go ahead and book your legacy planning session already. The QR code on the right is a link to my Square site where you can book a 2-hour working session with me, and we can get this whole process started. So again, thank you so much for spending your evening with me. I hope that you were able to take away with you some information that is helpful for you. And yeah, have a great evening. All right, take care.